I'm Nate Soderstrom. I'm senior at the Capital Forum. We have a great event, great panel, talk about AT&T Time Warner. Thank you everyone for being here today. Thank you to American University, Washington College of Law, all the attendees, panelists. Going to quickly introduce everybody, starting closest to me, Steve Salop, professor of economics and law at Georgetown University Law Center. I also think it's fair to say one of, if not the leading experts on potential competitive effects arising from vertical mergers, other transactions. So certainly worth listening to here. Next, we got Alan Grunis, antitrust lawyer, founder of the Concurrence Group. Alan spent more than a decade as a trial attorney in DOJ's antitrust division, where he handled media issues, including television, radio, movies. So certainly smart on these issues. Finally, Hal Singer, principal at Economists Incorporated, also a senior fellow at the George Washington Institute for Public Policy, and the adjunct professor at Georgetown McDonough School of Business. Hal's done a ton of work in the media industry in the context of vertical pay TV, antitrust matters in particular. So certainly, again, extremely smart on this stuff. So we have a great panel, and with that, I'm going to kick it over to Alan, who is going to give us an overview of what he sees as the issues here.
Thanks, Nate, and thanks to Capital Forum and American University. And I got to say, it's a real pleasure to be on the same panel as two of my favorite people who happen to be also really great economists, and one former expert witness. So this isn't the first time that the government's alleged that a vertical merger is illegal, but it's the first vertical case that's being litigated in more than 30 years. So in that respect, it's significant. Some people are already calling this the trial of the century. I think that goes too far, but it's definitely the main event in the antitrust world right now. So I'm on the record as saying the public wins here, regardless of who wins at trial. Several reasons, one of which is that DOJ has been developing an approach to vertical mergers for a number of years. You can look at the Comcast NBCU complaint and the number of speeches and articles which touch on what DOJ's approach is, but the approach hasn't been tested in the courts. Contrast that with horizontal mergers where there have been plenty of litigated cases and the law is reasonably clear. Both the agencies, FTC and DOJ, and businesses have guidance when it comes to horizontal mergers. We also need vertical cases to be decided by courts. Nobody wants to go to court. It's the path of last resort, but it is the way that Congress intended the antitrust laws to develop. Okay, so I'm going to do an overview, and let's start with the DOJ side. The primary unilateral effects theory in the complaint is about weaponizing Time Warner content. According to the complaint, TBS must have basic cable networks that AT&T can use as a competitive weapon if the merger goes through. The complaint says it can force competing distributors to pay hundreds of millions of dollars more for these networks. The slide talks about what the complaint alleges counts as must-have content and how this would work, combination of potential withholding strategy and a raising a rival's cost negotiating strategy. And then there's the kicker in the complaint because the allegation is AT&T can raise rates to its competitors, it can also raise its own prices. Okay, so the power is enhanced because AT&T could also slow the growth of online video services. Specifically mentioned in the complaint is Dish, Sling TV, that offers skinny bundles, which are cheaper packages with fewer channels and do not require a set-top box or satellite dish. So in addition to a price effect, there's a claim that the merger will hinder innovation. The innovation complaint is similar but a little bit different from what was in the DOJ Comcast complaint. This power is then enhanced because AT&T, according to DOJ, would get control of HBO. The complaint alleges HBO is currently used by distributors to attract new customers and to keep unhappy customers from leaving. But after the merger, AT&T could deprive competing distributors of this tool. So those are the unilateral effects theories, that at least as I conceptualize them. DOJ's also raised an interesting coordinated effects theory, which suggests that the merger may facilitate coordination between the merged firm and Comcast, since both companies face similar threats from new rivals. And the implication here, I think, is just because the Comcast NBCU deal went ahead with conditions doesn't mean that this deal should go ahead. Okay, so what about the defenses? The merging parties argue that the marketplace is rapidly shifting. Firms like Apple, Netflix, and Amazon are upending the video market. Parties deny that Time Warner has any must-have programming in a world that's awash with content, in their words. They say that the merger won't change the incentives to distribute Time Warner programming as broadly as possible. And in terms of Comcast, far from seeing a heightened risk of coordination, parties see the merger as intensifying the competition with Comcast. They also point to multiple benefits from the merger, including, interestingly to me, that the two parties together would be better able to bust up the Google, Facebook digital advertising duopoly. And since DOJ would not agree to a Comcast-style remedy, the parties have done a little self-help. Turner has apparently offered all of its distributors binding baseball-style arbitration if there is a price dispute, and is guaranteed that it will not go dark while any arbitration is pending. So in summary, the claim is that the deal would make AT&T more competitive against tech firms on the one side and the traditional cable companies on the other. The implication to me is, if you're worried about market power or gatekeepers, take a look at Google and Facebook, take a look at Comcast and Charter, take a look at Apple and Amazon, but leave us alone. So will the trial be colorful? Well, it involves a big Hollywood studio and content company, but involves the business side of the business, not misbehaving celebrities or movie producers, I was thinking of, actually. You know, I'm thinking about Dan Petricelli's other clients here, so Presidents is apt. So I have my doubts that it's going to be all that colorful, but there are certainly some important issues at stake here, and I think if one thing is clear, this is not fake antitrust.
All right, thank you, Alan. Steve, any thoughts?
Yeah, sure. I mean, what I was asked to do was start with, we're going to start with the unilateral, then we're going to talk about the coordinated, and then we're going to talk about the remedy. So I'm going to start off just talking in a little more detail about the unilateral theories. The idea in economics terms is that because of the vertical merger, AT&T, Time Warner are going to have increased leverage to negotiate higher affiliate fees for the Turner content from the MVPDs like Comcast and Charter and Dish, from the virtual MVPDs that are going to want to use the content like Sling and Amazon, and from wireless competitors like Verizon and T-Mobile. So there's separate targets for the potential higher prices. And the idea is that they'll be able to negotiate higher prices because Time Warner will say, well, you know, last year we negotiated this price, but now, you know, if I don't make a deal with you, I've got less to lose because you're going to lose some subs and they're going to go over to AT&T, and now that's going to go into my pocket. So you've got to offer me a better deal than you did the last time. So that's the basic unilateral theory. Carl Shapiro, the expert for DOJ, estimated an increase in Time Warner's affiliate fees to MVPDs, just to MVPDs, of about $750 million a year. Okay, so like $5 billion for 7 years. But the DOJ alleged harm, they're focusing on harm in the subscription market, in the downstream market. And so the issue is how much of that would be passed on to consumers in higher subscription prices. So Shapiro estimated there as a first round effect on the MVPD subscribers of around roughly 300 million, okay, per year. And then what he did was he apparently, it's, you know, we haven't seen the expert reports, I should say, so we're just basing this off what the DOJ says in its brief and what AT&T says in its brief. So it appears that what Shapiro did was he ran a merger simulation model here, a vertical merger simulation model, and found estimated higher subscriber fees of $436 million per year for MVPD subscribers. So over 7 years, that's around roughly $3 billion. Now, these estimates by the DOJ's telling are conservative because that $3 billion over 7 years does not take into account increases in prices to the virtual MVPDs, to the Slings, to the Amazons, to the Sony Views. So that would bump up the number somewhat. And it also does not take the coordination into account. So if at the same time that Time Warner is raising its fees, NBCU is raising its fees, that you generate some coordination, then of course that $3 billion will be somewhat higher. So that's the basic economics of their unilateral story. Of course, you know, I'm an economist, Hal's an economist, so we like to focus on the economics, but there are lawyers involved in this case too. And there apparently is evidence from AT&T documents, though some of it is redacted. And what I find the most interesting part is that DirecTV was an adamant objector to the Comcast-NBC merger, and so the complaint has got a lot of juicy quotes from DirecTV about Comcast-NBC that then they're applying to this deal as well. Hal?
Yeah, so Hal, I know you've been kind of hesitant to speak publicly on this deal and share your thoughts, but I'm wondering if you could break your silence.
Thanks. I appreciate you guys having me, and thanks especially to Teddy for inviting me. I had some opening remarks that kind of frame the issue as I like to frame it, and then I'd like to get into the unilateral effects in a bit, if that's okay, or maybe on the next round. So let me try this out on you. I don't represent a kind of libertarian view towards vertical mergers. I actually think that some of them should be blocked, just not this one. I think that the DOJ should block a vertical merger that would, and here's the standard, I want to see if I can get Stephen to agree with me, materially impair the ability of a distribution rival to compete effectively and thereby substantially lessen downstream competition, in this case for video subscribers. In fact, I cite Stephen's work often when I'm working for plaintiffs in antitrust case, and he's raising rivals cost framework, and I want to see if we can get an agreement that materially impair the ability of a downstream rival, given a 27-cent per month per sub increase, would do that. That's what we're going to fight about. If a rival's costs were to go up by a few pennies a month per subscriber, would that materially impair their ability to compete effectively in the downstream market such that they would no longer be able to constrain AT&T/DirecTV to the same degree that they have been doing up until now? I would submit to you that there are two conditions we want to look for to make a determination of when this material impairment is going to occur in a vertical case. The first condition is that the integrated content must be must-have. That is, it can generate a forcing function. It could cause departure. If I withhold it from you, some of your customers are going to leave to follow that content. The second condition that we want to look for is that the integrated distributor must have a substantial footprint in the downstream market. After all, if they are atomistic in the downstream market, then even if they could get a subscriber of a rival to defect or depart, there would be very low chance that that defecting subscriber would land on their property. So we want these two things to be present. And in my position, neither one of the conditions are satisfied here, and so we should, instead of blocking the merger, we should approve it and constrain the behavior, just as an insurance policy with the behavioral remedy. Now, the DOJ's decision here has huge implications on vertical integration in the media, as a DOJ victory would mean that any deal with even the slightest predicted price effect could be condemned. The Nash bargaining model that's used by DOJ's expert, Dr. Shapiro, who I think is amazing, by the way, would generate positive price effects under any parameterization. That is, any parameterization that didn't involve zeros for the three key inputs. So we have to be very careful to condemn a deal simply because the price effect is positive. What the DOJ is seeking here is tantamount to a categorical ban on any vertical merger in the media industry. Now, should the Food Network, just to pick a content that I hope everyone can agree is not must-have, be required to fund and develop customer service, network administration, direct marketing, and sales capabilities in order to stay in business in an a la carte, over-the-top environment because it cannot sell itself to a small distributor like Dish? And if I could, I'd like to say one thing quickly on remedies and how they've worked out in the Comcast-NBCU deal. Contrary to conventional wisdom, the behavioral remedies used in Comcast-NBCU order and in program carriage and program access disputes generally have been successful, and I should know. I've gone up against Comcast on behalf of Tennis Channel, NFL Network, Masson, and Project Concord. We extracted settlements in two cases, NFL and Masson. That means we got Comcast to fold before the judge could make a decision in our favor. And we got to a finding in favor of my client, in the complainant's favor, in the other two cases, Tennis Channel and Concord. Now, those findings did not produce the relief for the complainant due to a faulty appeals process, which I consider to be outside of the adjudication per se. And that can be resolved via binding arbitration or removal of the FCC commissioners from the appeals process, who have always voted along party lines in every case. Now, even when I wasn't involved, complainants have won relief thanks to the NBCU protections. Bloomberg secured preferential positioning in their neighborhood with Leslie Marks as the expert, and an unnamed OVD won access to NBCU content per the annual DOJ report on Comcast NBCU. I'd consider those to be two more wins. It is proof that I, like Time Warner's content, am not a must-have input.
So Hal, there was a lot in there. Steve, want to kick it back over to you? I think on the unilateral question, and in particular the idea
Well,
that...
let me respond to what you
Please.
said. The AT&T argument is that the Turner content isn't worth very much, and if Turner would drop, would do a blackout for Dish or anybody else significantly, it would really be a disaster, catastrophe for Time Warner. And the problem with that theory, with that claim, is if Time Warner content is so worthless to an MVPD, then why are they paying $3 or $4 a month for it? They must be getting something for that $3 or $4 a month. And that is to say, if they didn't have access to the Time Warner content, they would lose subscribers. I mean, that's the main thing they care about. So the idea that the loss of Time Warner content wouldn't cause any departures, it doesn't add up. It's not logical. Now, DOJ estimated the departure rate to be about 12% at the MVPD level. And I have no idea whether that's accurate or not. I mean, it's based on evidence that's not in the record. So we'll see. But you've got to have. But what's clear to me is that in order to generate a $3 or $4 affiliate fee, there has to be significant. There has to be significant departure, and this methodology, economists call this the calibrated departure rate, that you start with the affiliate fee and then you plug in the advertising revenue and some other data, and you can estimate, you can calibrate what the departure rate would be in order to justify the $3 or $4 affiliate fee. And you know, you could make that really complicated, or you could do it in a really simplified way. Kevin Murphy, who was DirecTV's expert in Comcast NBC, offered the same calibration methodology in attacking the Comcast NBC merger. So I would think DOJ is going to do something similar to focus you on the justification for the departure rate. As for the substantial footprint, if you raise costs of all your rivals, of all of them, then you're going to get a substantial bump, and that's what's going to make it profitable. So it's not so much your initial market share. That would be true if you were only raising the price to one person, but if you can raise the price to everybody, then you've got a lot more power. So is this thing significant? A few pennies a month? $5 billion over 7 years in higher fees. $3 billion in higher prices paid by consumers. That's a lot of lattes.
That is the Starbucks
I don't
latte.
know what latte you're getting. Mine at $4.50 and 27 cents. You know, doesn't even get you the foam on the top. But,
Yeah, well, if you buy enough of them, if you and 100 million other people buy those lattes, it's real money.
So to move on from the latte pricing discussion,
but can I, in seriousness, can I respond to
please
the
do it,
departure
especially on the
stuff?
departure rate,
Yeah, let's
because
go.
I know you have some thoughts there.
Yeah, let's go to the departure rate, because we have to recognize that it really comes down to the departure rate. There's not a lot of wiggle room for Carl Shapiro here, in the sense that there are three inputs that are driving the Nash bargaining model, and none of them are good for the DOJ, and two are known and bad. At least there's some uncertainty over the departure rate. The first one is the video margins that DirecTV earns, which are paltry. They're razor thin, and so it just doesn't get AT&T excited to take losses at the upstream in order to win a downstream if that downstream business is crappy. All right, and we have razor thin margins in the downstream business. So there's nothing. Well, I saw operating margins of 8.4% in the AT&T 10K. I've heard other video distributors are losing margins to the point that they're getting out of the traditional
It's
video
variable
business
margin
entirely.
that counts. It's the variable
the variable margin, right? And the reason why it sucks is that you have to pay at the margin $7 or $8 to ESPN, right? You got to pay your $5 or $6 to the RSN. And these things are unescapable. And it really makes it that business not very exciting. And they don't escape those costs when they buy Time Warner. They still have to make those incremental payments each month for video sub. So but we can eventually come to an agreement as to what the margins are, whatever they are. I suggest they're small. The next thing is the footprint. When we do these foreclosure models, we do it pairwise. We do it with respect to each distributor individually, and that's how we have an estimate for the rate at which you're going to attract a departing sub to land on your footprint. I believe it's the diversion rate, and we do use an adjusted measure of your downstream footprint. And the problem for DirecTV is just that it's, at least relative to, say, Comcast, which had 40, 50, 60% market share in the local markets where it was getting must-have programming. We have DirecTV in the high 20s. So that's a problem, but that's knowable, and we can measure that, and we're not going to fight once I think two economists can figure out what DirecTV's share is, right? So the only wiggle room that we have is on the third one, which is the departure rate. And here Shapiro went to the Suddenlink example, and he estimated, given when he's looking at churn around a standoff between Suddenlink and Time Warner, he estimates what he thinks controlling for all of their factors is 12%, as Stephen said. Departure rate. What AT&T said back in the brief is that independent analysts have studied the exact same dispute and have estimated the departure rate closer to 5%. And if you hold all the other parameters in Carl's model constant and just move the departure rate down from 12 to 5%, the price effects go to zero, right? And now AT&T says, and by the way, our expert has looked at it, and he actually thinks that Carl failed to control for X, Y, and Z, and once you control for those things, the departure rate from this episode is actually zero, which of course you can't go less than zero price effects, but you get my point. Our problem now, we go to a fact finder and we say that we have a confidence interval that surrounds our predicted price effect. And that confidence interval contains the number 0 cents per subscriber per month. So we think it's zero. it stays at 0 all the way up to 5% departure, and then it starts going up. And the expert over there says at 12% departure, you get a 27 cents per month subscriber. That's the problem for the fact finder, is are you going to condemn a merger where you have uncertainty over what is a very, very small price effect? Again, does it trigger this materially impaired standard that would substantially lessen competition in the downstream market? I just want to add two things on departure. The brief, AT&T's brief also mentions a case involving Cable One in which they think the implied departure rate from that episode is 0. I'll note there are some horrible Charlie Ergen quotes that I hope they throw up on the wall. You know, when Ergen got into dispute in the fourth quarter of 2014 with, it only involved Cartoon Network and CNN, just to be fair, it wasn't the whole portfolio. But during that dispute, Ergen said some disparaging things about CNN. He said it's no longer must-have content, and he said this whole episode is a non-event. And I've studied what happened to their churn rate in that fourth quarter, and it's high. They lost about 50, 60,000 subs, but if you compare it to their loss in surrounding quarters on either the front or the back, they were losing this number of subs throughout the relevant time period. That is to say, the 60,000 subs they lost in the fourth quarter 2014 is not statistically significantly different from what Dish was bleeding on both sides of the experiment. So I think that when you look at the totality of these episodes, Suddenlink, Cable One, and Dish, you come up with a very, very small departure rate. And if that's your input, that drives the model, and that's going to put a price effect that is dangerously close to 0.
Yeah, I think all I want to say in reply is that I think what Hal set out is that's the kind of evidence that they're going to be fighting about at trial. And so you can see the sort of economic back and forth that's going to take place. And so the question is going to be, what's the judge going to do with it? Is he going to believe Dennis Carlton or Carl Shapiro? That's one approach. He could say, oh, well, these people played to a stalemate. I'm going to look at the documents. There's a lot of different, what we're trying to predict is what Judge Leon is going to do. Now, what I would say in the end is you can throw all the dirt on these estimates you want. In the end, they're paying $3 or $4 for Turner content. Why? They must be getting some out of it.
You must be saying in the aggregate, right? Because in the aggregate, right? Because TNT and TBS go for around $1 per sub per month. And people are very quick to say, oh, because there's some sports thrown in there that we ought to think of.
I'm using I got the $3 just for the record from the DOJ brief, which you can back out an amount of $3.30
Right.
as an average price for the bundle of Turner services.
But can I poop on the sports on TNT and TBS? What I just want to point out is that it's very dangerous to kind of lump all sports together and say that, you know, that all things are equal. There's regional sports, that's must-have. The FCC has recognized it as such, right? And that's because if you take away the Washington Nationals from a Washingtonian, that fan is going to be really pissed, and he's not going to be upset. He's not going to be happy to learn that, oh, you've got some random game, out-of-market game on TBS this week, right? So there's a reason why TBS and TNT go for $1 a month, and regional sports networks go for $4, $5, $6, $7 a month, and why ESPN, which has consolidated a whole bunch of valuable sports rights, even though they're out of region rights together, trades for something on the order of $7 a month. I mean, the market is telling us that the stuff that's on, and I love Charles Barkley to death, right? But the stuff that's on TNT, despite Charles's charisma, just doesn't command the same respect in the marketplace as that on regional sports networks.
So the good news is we have ESPN and regional sports network, some of them combining, so we'll see how that plays out in practice with Disney Fox. So want to move on to coordinated effects, which is a big piece, and Alan, want to draw you back in here. Obviously, we've heard from both economists on the unilateral piece. When you think about the idea that AT&T, Time Warner could coordinate with Comcast and NBCU to exclude, especially rival virtual MVPDs, how do you think about that argument? How do you go about showing that argument? Coordinated effects always, to me, seem a bit wishy-washy relative to unilateral, where you're really kind of modeling things down to a T. How do you think about the coordinated equation here?
So, I don't think of coordinated effects as wishy-washy. I echo Judge Posner, who said coordinated effects really, and collusion, both coordinate, tacit and express collusion are the heart of antitrust. So I was on a program a couple weeks ago, and Luke Frobe gave the lunch address, and he said, one of the problems economists have is that the economic theory is lagging a little bit on coordinated effects to where it is on unilateral effects. But, I want to start by saying I think coordinated effects is key. I worked a little bit on the beer merger, and one of the great mistakes I think that DOJ made a number of years ago was to allow the Miller-Coors joint venture to form, where industry coordination began almost immediately, according to the economics I saw after that, okay? I'm sure DOJ was focused on unilateral effects and the efficiencies of moving production around and whatever. The complaint and the brief don't go into a lot of detail on coordinated effects, but the brief does suggest that there are going to be more opportunities for Comcast and AT&T to interact post-merger, which is one of the factors with coordinated effects. And then, to me, and I think it's kind of common sense, that both of these as sort of legacy businesses in a way share a common interest in, if they can, slowing down the development of rivals to the traditional pay TV services. One of the quotes in the complaint, in the DOJ complaint is, and we'll have to see what the document actually says, but we can extend the runway for this decline. We're on a limited runway. We can extend it, and it's obviously. I say obviously, maybe not obviously, but it seems to be in the interest of the traditional providers to keep the business as long as they can, be in the best position, obviously, they can to transition. And one of the ways you can do that is by slowing the development of rivals.
Yeah, absolutely. Steve?
I would just, add a couple, two other points. One is that in terms of the communication and the incentive, Comcast and Time Warner and now DirecTV are partners in Hulu. So they have, which is a pretty powerful, but at least potentially really powerful service, since Hulu is Comcast, Time Warner, Fox, and
Disney.
And Disney, right, Disney, the other one of the big four. And of course, DirecTV has DirecTV Now, so it would like to slow Sling and Sony View and so on. So they've got common incentives, they've got ability to communicate. The other point I wanted to make is more, I think, forward-looking. Hal talked about if you stop this merger versus if you allow this merger. If you imagine if you allow this merger, then Verizon's going to buy somebody, and Charter's going to buy somebody, and you're going to have a set of vertically integrated firms, each of whom depend on one another for content. I mean, it's not like AT&T is just going to rely on Time Warner content. They're going to want the content from Disney and NBC and so on, and everybody is going to want the content from everyone. And in that situation, they can charge each other high content fees on a reciprocal basis, use MFNs to make sure that everybody knows what everybody else is doing. And by raising their own content costs, these vertically integrated firms will have an incentive to pass on the higher content costs in the form of higher subscription fees. So it's a very nifty way. This reciprocal dealing with MFNs is a very nifty way to tacitly collude. And that's what I think is the end game. And I think one of the questions for Judge Leon, if I had a chance to quiz him, would be, does the incipiency concern about mergers and vertical mergers in particular, discussion about momentum, would that apply? Would you apply this coordination theory to the AT&T Time Warner deal?
Can I
Now,
take?
coordination.
Yes. I won't be as charitable. And I find it interesting to hear that we can't allow this vertical integration to occur despite the fact that it has already occurred with Comcast and NBCU. So I guess in a perfect world, only Comcast gets to be vertically integrated. No one else gets to be. Boy, they've got some good lobbyists, I imagine, to have that arranged. On the coordinated, I think it's highly speculative and it wouldn't survive on its own. I kind of see it more as window dressing. Of course, AT&T and Comcast are not allowed to coordinate explicitly. That's in violation of the antitrust laws. And if they did, the DOJ should bring the hammer down on them. So what we're talking about here is tacit coordination. And what the DOJ would have you believe here is that AT&T runs the math on this foreclosure, and they find that the upstream losses are just too big to justify messing around this way. And there's just not enough benefit to the downstream to make up for it. They would have you believe that if somehow there's tacit coordination going on with Comcast, that calculus is somehow changed. And I'm trying to figure out what is it that Comcast could do without being overt. But what is it that Comcast could do that would upset the calculus, it would reverse the calculus such that now it would be profitable to engage in this? And I haven't heard anyone yet articulate that theory to me.
Couldn't joint withholding lead to more departure than, like if you withhold NBCU and Turner, couldn't that lead to more departure than withholding?
Yeah, it could lead to more departure, but here's the problem: is that I don't think that DirecTV, and I mean this as nicely as I could be, I don't think that DirecTV is perceived, given that it lacks a wireline broadband connection everywhere it exists, is viewed as a close substitute to what Comcast is offering with a bundle of video and wireline high-speed internet connection. It is true that AT&T has upgraded its DSL connection in many homes across the country, but nevertheless, there are places where either AT&T doesn't exist or AT&T exists but has a DSL connection. And so what I'd be worried about is that even if AT&T could count on Comcast being mean to, say, Verizon, how many of those customers would be willing to gravitate just to DirecTV's video? That's what would worry me. So I don't see how, and you don't get to sit around and plot this out, right? This is tacit, and so I don't see how it changes the calculus much. I think that I want to just parrot back a few comments in the brief that I thought were interesting and could resonate with the judge. And so AT&T was making a big deal out of the fact that there is a conflict of interest between AT&T's vision of what the future video will look like on the one hand, that is a wireless connection with a virtual MVPD running on top of it, and Comcast vision on the other. And that because of these conflicting visions, the two parties would not be in sync when it comes to, say, going after virtual MVPDs. AT&T might need them because it could be a good thing for the development of wireless as the alternative to cable, whereas Comcast sees it as a bad thing. AT&T also brought up the fact that Comcast isn't everywhere, of course, and so if they wanted to get nasty with a virtual MVPD, it might end up in departure or weakening that customer or that firm, but the diversion would not go to Comcast because Comcast isn't everywhere that virtual MVPD is. So the brief, I think, made some interesting points as to the conflict of interest might undermine a coordination theory.
Fair enough. Additional comments on coordinated, or should we move on to the arbitration, no blackout offer?
I think given the time, we should probably move on.
Steve, the remedy, thoughts?
I thought Hal was going to
Hal, thoughts on the
justify
remedy?
the
Alan,
remedy first.
Whom on the
But I was
panel
just
would like
talking.
to?
They don't want to hear me keep going.
Does nobody want to talk about this?
I'll think
Cal has the burden.
I have remedy.
Cal has the burden.
Oh, I have remedy points. I have remedy points.
That is an open question.
The one with the burden goes first.
Okay. All right. Now, first point on the remedies. DOJ's brief said that behavioral wasn't workable here because the FCC wasn't available to adjudicate. Okay? And that hurt my feelings. I've been involved in more adjudications, both in the FCC context and outside, than you can shake a stick at. And I can tell you, and I mean this, again, with a lot of love in my heart, there are no government bureaucrats needed to adjudicate the dispute. You need an arbitrator. and sometimes you have an ALJ. You need a law clerk, and you need a source of authority, and that's it. So this notion that we have government employees doing something during the adjudication, okay, is baloney. And I've been in about 10 of them, okay? So it hurts my feelings to hear that this is somehow impossible to do here. And another thing that they're peddling,
Maybe
which,
it's a judgment
which
on
is
you.
which is fake. Another thing that they're peddling, which I think is fake news, is the notion that this is going to somehow drain resources or be a burden on taxpayer or burden on high agency. You hear high agency, high administrative costs. Baloney. Okay? Even in the case where the FCC's ALJ adjudicated disputes, and I think I've been in about 5 of them, okay? He's a salaried employee of the FCC. And so the notion that in his, yes, he did have a law clerk next to him, but the notion, and she was probably salaried too, and so the notion that this is imposing incremental or burdensome cost on an agency to adjudicate a dispute is just far-fetched, and I really wish that they would stop saying that. The next point I wanted to make is that, I wanted to, on AT&T's arbitration offer, I think it's a good start. I do think it upsets the bargaining model that Shapiro used. And Shapiro, when asked at deposition, did he accommodate it, his answer was no. And I don't know if that was the right or wrong answer, but certainly if you're trying to measure bargaining between the two parties, and AT&T has agreed never to turn out the lights, that upsets the bargaining. I mean, that's going to affect the bargaining in some way. And so you're not going to get the 27 cents per month. You're going to get something less. I think it's a good start. I would go a little bit further in terms of the offer had AT&T asked. I think that of all the things in the content portfolio, that HBO is the only one that's anywhere close to must-have. And I realize that HBO is available right now over the top, and so that largely thwarts any foreclosure strategies with respect to HBO, but I think they should have just committed to, or the judge should compel them to commit in the consent, the notion that they're going to keep that standalone offer on the table, and that they'll never charge a higher price, say a penalty price, to some customer who shows up with a non-AT&T ISP. I would have liked to have seen that. Finally, DOJ fairly notes, I want to be fair, I want to say one nice thing about the DOJ's brief. They do say that fair market value is ambiguous. And I'm sympathetic to this because I've actually seen an arbitrator, no names, get turned around in a case involving vertical integration and fair market value. So here the term fair market value should mean what an independent or standalone owner of the content in question would charge in an arm's length agreement. That is, remove the vertical integration and ask what's the fair market value, what's the price. And I think that ought to be made explicit in any consent order just to prevent an arbitrator from ever getting confused again.
Okay, well, we're running out of time, so let me just make a couple points. The first, and with credit to Jonathan Baker, who's over there and will be on the third panel, consider this remedy. Suppose AT&T had said, when it wanted to merge with T-Mobile, don't worry, no problem, we offer arbitration to any customer that thinks we're charging above fair market value after the merger. And therefore, you should just let us merge. Okay? If you like the remedy here, it also applies to horizontal deals. It applies to everywhere. We can give up antitrust. We can turn it all over to arbitrators. And so I think that's one problem. And I expect the judge will have a problem with that. The second remark I wanted to make is that arbitrators are just not qualified to do this. What arbitrators are qualified to do is figure out what is commercially reasonable. But what antitrust judges care about, what antitrust law cares about, is whether prices are competitively reasonable. And the arbitrators just, that's not within their mainstream of their job. So, and Hal just said that, okay, well, I'm gonna tell the arbitrator, don't use fair market value that you've been using all these years as an arbitrator. Use this other concept of fair market value, which is totally hypothetical. And I just think they're gonna have a lot of trouble implementing it.
Alan?
So, I I think I look at this as a variation on litigate the fix. So litigate the fix has become popular. It's where parties do ideally parties do their own divestitures beforehand, kind of a fix it first, but more often parties enter into agreements to sell assets. That happened in Cisco. It was an issue in Aetna. I think it was tried as well. It occasionally works. What I don't understand is it's really crashed and burned in the last number of times it's been attempted. In Cisco, it completely failed.
With the structural fixes.
And Aetna too, I guess, right? But so why do people keep doing this? Other than you sort of, the way the institutional design is, you figure out what the agencies are most bothered by, and then you kind of, tweak your deal, or you adjust your deal to deal with that. And you say, all right, now you got to prove that the deal as adjusted is still anti-competitive. I think the whole litigate fix thing is a bad idea to begin with, okay? And I'm glad it's getting shot down. But this one's even a little bit odder or more clever, because it's a litigate the behavioral fix, right? It's not even we're going to sell assets to get this deal through. It's we're going to unilaterally extend offers to all 1,000 distributors. And it's not even a kind of fix it first. It's a contingent behavioral fix. So I thought DOJ's brief was pretty good on talking about the brief on the motion in limine. I mean, if I were the judge, I'd probably want to hear this, and that's what happened in the pumps case. The judge denied a similar motion in limine. Wanted to hear it and then shot down the fix.
Should we start using? Oh, sorry.
But I want to just make one last point, which is, there's a multitude of reasons. I talked about this in the Comcast Time Warner Cable deal. We briefed it as well. There's a multitude of reasons to think that behavioral remedies don't really work very well to keep from price increases, particularly. If you're worried about price increases, behavioral remedies are not the way. Baseball-style arbitration, I know it's, people at DOJ have liked it in the past.
It's good stuff.
You like it? You like it too? Okay. I'm glad
Can
you
I
like
tell you why
it.
it's
I'm
good?
glad
Let's
you
give it
like
a
it.
help. And why not? Why isn't this?
Can I-
Why isn't this a cure-all for horizontal merger? Any kind
Well,
of. Let's go to arbitration.
I rejected that hypothetical of Stevens. Of course, we'd never expect a consumer to bring a complaint and hire an expert to come up with, to come up with an offer for what's the best price for fair market value. But let me say a few things here on baseball style. I think it's worth just me saying what it is and why it's so good, and why it kind of keeps economists honest, or valuation experts honest. Because there is a number, and that's the truth. That's what is this thing how should this thing be trading if it weren't owned by a vertically integrated distributor? How much should this thing go for? And by the way, we have a very recent, fresh deal between Time Warner and Comcast, an arm's length agreement between a non-vertically integrated Time Warner and Comcast. That's a pretty good estimate of the fair market value of the stuff, but I digress. You have two parties, and you're trying to make an offer and convince the judge or the fact finder, the arbitrator, that your offer is the fairest of them all. It is the closest to the truth, right? And so if you go if you're the access, if you own the content, for example, and you bid too high, right? To the point where it's a joke, the arbitrator could go with your adversary's choice, and the adversary might come in with a price that's too low. So it induces both parties to kind of temper their enthusiasm to be extreme and to get as close as they can to the truth, and maybe you fudge a bit to bring the needle over to your side. But if you go too far, you could really do yourself damage. That's the spirit. That's the logic behind the baseball style arbitration. And I would just, I think Stephen may have said that he doesn't have faith in the qualifications of arbitrators. And I would say, with the exception of the one that I mentioned earlier, whenever they go with me or my client, I would think that they are eminently qualified.
That's fair. We are, I think, out of time. I think we could have done this really forward.
You have
probably the entire
questions?
day.
You have questions?
Should we do an audience question or two? Can we do
Yeah.
that? Normally, there's somebody going around with a microphone that chooses question.
This relates to the remedies for baseball style arbitration. The argument from, and I'd just like to hear your response, the argument from the smaller MVPDs and the smaller networks is that we can't possibly afford it. We can't go through that process, paying fees to economists and lawyers. It's, their argument is not at all the FCC government time, it's all the lawyers and economists that you have to hire to go through this proceeding. And Bloomberg and Tennis Channel could do it for all those years and years that it took to fully litigate everything. But the small guys just can't. So I'd like to hear.
Well, I have sympathy here, but I will note that an unnamed OVD was able to secure access, according to the DOJ's report, so they were able to incur the cost. I was Project Concord's expert, and we won in front of the arbitrator on fair market value.
And went bankrupt. Yeah, it went bankrupt.
Well, so what,
No, isn't that right, Hal? I mean, just, let's keep the facts on the table.
we're not going to stray from the facts.
Okay.
I'm going to tell you this. Look, I've had a victory taken away from me from Kavanaugh on the D.C. Circuit, and I've had a win taken away from me in Concord, and more recently a win taken away in GSN v. Cablevision. So I feel this more than anyone, and I can tell you that there is a fix to this if we're going to do baseball-style arbitration. The burden does not come in the hearing. It doesn't take that long to get to the hearing. You have your hearing, your expert shows up, and then there's a post-hearing brief and a decision. That's not the pain. The pain is in the appeals process, right? And so we fix the appeals process, we can make the adjudication work. And I'm offering you a few suggestions. One is make it binding, and I think there's precedent for that. It gets the defense lawyers very upset when I say binding, but there is precedent. We've done it before, right? No appeals. Now, alternatively, you want to preserve the appeals to keep the defense guys happy. Let them go straight to the D.C. Circuit, skip the FCC commissioners who are highly politicized and vote their party on every occasion, if I didn't say that before. But in the meantime, if a complainant has prevailed in the first stage, that remedy ought to be in place. You shouldn't have to wait until the D.C. Circuit hears the case and rules, which can take a year or two. So those would be my fixes to give it some more teeth.
One more.
I have a question for Steve. It feels to me pretty disingenuous to say the remedy that they've offered is the same as a we won't raise price remedy. I mean, they could have offered that remedy, right, which they obviously didn't. But it feels like in this instance, one, is this actually a remedy? Meaning, does it solve the harm after the harm occurs? Or is it actually a reason why the harm won't occur? Because a key input into the bargaining leverage model is the ability to be able to withhold the content. So if you actually look at the relative strength of Turner as a party, which has the ability to withhold, but is not vertically integrated, they have one set of incentives, versus AT&T, when it's combined with Turner, that can't black out, but may have more power because they're vertically integrated. And the fact that you are not able to black out, is that a remedy, or is it a reason why the harm never would occur in the first place?
You can say a remedy can either deter the bad conduct, or a remedy can undo the bad conduct. What you're saying is the remedy would deter the bad conduct, just like a divestiture could deter the merging firms from raising price. So it's, in terms of the economics, it's pretty much the same. The issue is whether, I guess there's two issues. One, and I guess they'll talk about this on the later panel, the remedy only comes into play if the court finds that the deal unremedied violates Section 7. Now, the way you're posing it would be different if it were really a fix at first. If they unilaterally changed the contract and they said, we're going to do this regardless of what happens, then it would be more of then you could find that Section 7 is not violated because Time Warner has all these contracts in place. But given that they've made it contingent, you have to have a finding that the unremedied merger violates Section 7 before you get to the remedy.
But haven't they said that? Because
No, they haven't.
In this situation, if the let's say the government just loses flat out, this remedy still exists. So it's very different from.
No, it doesn't.
Yeah, they did. They offered an irrevocable, binding contract for 7 years to all of Turner's counterparties in the event
If
that
the deal gets through, right?
Yeah,
But
that
that's
has
the
nothing to do
contingency.
with a court order, it has nothing to do with the DOJ
Yeah.
agreement,
saying if the
nothing to
DOJ
do with
loses,
anything. So I'm
No,
saying,
I get it.
why should we see this as a remedy? This is behavior that will exist in the marketplace. You know, it changes the competitive dynamic of the marketplace.
So
not
it's a fix,
divestiture.
it's a fix it first. It's an attempt to, and it's an attempt to do a litigate the fix strategy, and it's clever. It's, you know, it's highly clever. You know, I don't think it's a mistake that, you know, Rich Parker's firm that tried to do litigate the fix in Cisco, you know, same firm is trying to do litigate the fix
But the
here.
losses for litigating the fix in the past have not been sufficient. I mean, Cisco, the buyer in the Cisco deal had documents that said, we can't do this. The buyer or nobody can do this. They didn't say we can't, they said nobody can do this. Then they came in as.
Well,
the
they
buyer.
changed their mind.
And-
They kind of flipped
Okay.
partway through, so they were on the
And-
record
and
saying one
in-
thing first, yeah.
What was
That was a
it,
problem for
Aetna?
them.
Was it Aetna?
Yeah, we don't have to get into Aetna and Staples and all that. I mean,
There were just severe problems with the buyer. So I don't think this litigating the fix is the same as and falls into the same category.
Well, it's got one of the same issues though, which actually Hal's just kind of brought out, which is, and DOJ mentions it in its brief, which is it's a moving target. I mean, Hal is talking about how you tweak this to make it more effective. One of the problems the agencies, I think both agencies have with litigate the fix strategy is it's a moving, it is potentially, unless you say, I'm selling these assets, they're sold, now we're going to court, okay? And you're suing me on a new deal. It's potentially a moving target. And I think the other thing DOJ points out is this was a unilateral offer to 1,000 distributors, and DOJ says like 20 have taken them up. What happens to the rest? You know, you say it's irrevocable. What happens if you figure out a way around it? This is one of the problems with
My
behavior.
guess is if the deal goes through, the rest of them are gonna accept it.
Well, but it raises it does raise some of the problems of a company with incentives to do things one way, coming into a behavioral remedy that works against those incentives, then has some incentives to evade or avoid.
What I said in my article is that, which by the way is, you can get on SSRN, is that it just takes incredible hubris to think that a behavioral remedy, let alone a private behavioral remedy, is going to work. We know from regulatory economics that the regulated firms know more about the evolution of the market, they know where the skeletons are buried, than do the agencies, or in this case, the arbitrators. The market will evolve, and the firms are going to be able to stay one step ahead of.
I mean, I totally agree with you in most cases.
Thank you.
Most of the deals that we're talking about are horizontal mergers, where you have clear harm, you have a presumption of anti-competitive effects, and we know that in horizontal mergers, if you don't divest the assets, it
Yeah,
becomes really difficult.
But we
to
know
have-
that what we know, if you buy the theory, if you buy the anti-competitive theory, we know that they have an incentive to foreclose rivals. That's the anti-competitive theory. But you say the contract will deter them from exercising those anti-competitive incentives. And so that assumes that the remedy is smart enough to anticipate all the potential anti-competitive incentives in the future. And I don't believe that it can.
And with that, we have to cut the panel off. Sorry, we're running late. But again, like I said, I think we could have this panel for 8 or 10 hours. I don't think
I
we
would
should.
just say to Hal, you know, if this really isn't must-have programming, why don't they divest it? Be done.
And with that, we'll wrap it up.